So I'm very happy and thankful to be here and to take part in this conference. We have really fruitful and wonderful time, not only in scientific but also in socializing ways. So I'm really thankful for organizers, Central European Academy and Institute for Children's Rights. This is Professor Čulo, Margaletić and me will try to present a chapter book of Children in Private Law, a Croatian report. It was written by a team. We are all members of chair at the faculty of Zagreb, family law chair. And we usually work as a family, so whenever we can work together, and this is very good experience. I invite you to follow our example. So it is impossible to present everything what we wrote, because it would be just some facts. So I started with idea to present generally contemporary Croatian family law, and later Professor Čulo Margaletić will add some specific presentation about legal capacity, the rights of the child in court proceedings, and the rights of the child during adoption. So we are not more post-transitional. We are now a capitalist country as well, but we bring with her some good inheritance from socialist time, especially concerning the rights of the child, because we have non-discrimination of children born out of wedlock for a quite long time. I find it very important also in inheritance law. So there are no special differences between children born in or out wedlock, and I think this is our common heritage as well. And also their fathers are not discriminated for decades, and we can be proud of this, because in some Western European countries, fathers of children born out of wedlock did not have same rights as fathers of children born in wedlock, and we really struggled to ensure from the very early time that a child has the right to be represented and cared for by both parents without discrimination. Of course, in practice, it's another way, because the privileged parent is always this one who lives with the child, so it's a huge difference. Also, we became in socialist period a special, a separated branch of law, not together with civil law, general civil law, because we started to improve our branch, our family law. It's quite rare like right now. I know even in Slovenia, it's family law professors are part of civil law, as well as Hungary and in many other countries. I think one of the reasons that there is no enough interested academicians, future academicians, because we are poor professors. We are rich because we do what we love. This is our vocation. And many other professors, especially, it seems, sorry to say this, sometimes are engaged with some other branches of law that bring more money. So even our attorneys ask, if somebody comes to divorce, do you have any assets? Do you have any property? If you have, okay, I can earn. If you don't, then it's just psychiatry very often. So it is one of the reasons. But we preserved family law as a separate branch, and our department is called Department of Civil Law, or Civil Law Science, Civil Legal Sciences, and Family Law Science. And so our Professor Hrabar fought very vividly for this position of family law in Croatia. So very early, the Family Act in 1998 introduced the concept of children's rights. It was quite new in that time, and also I have to say that it's due to hard work and advocacy of academics, because we were always part of state commissions, of minister commissions, to help to draft a new law. So we really had very early pedocentric law, and it was met by some concerns. They said that children's rights are a time bomb in a family, because if you give too much weight to children's rights, then you would probably destroy the family, because of possibility of child to ask protection, and even sometimes be hostile toward family members and parents. Thanks God, it's not the true, although the time shows how that Foucault's pendula is coming slowly back. Maybe we really a little bit paid too much attention to children's rights in some circumstances, but especially when we talk about self-determination and so on in some fields. Simultaneously, in Croatian Family Act, parents are given primary role and rights to raise and represent their parents, although these principles is sometimes also endangered, and in public speech or in professional discussions, it seems like too traditional, and there are some requests that it is not so modern and popular to give the parents the primary role and the duties to do everything. I need to hurry up. Also we had in till 2014 the strong concept that both parents have to take care of their children, and this was endangered in 2014, where there was a legislative change, and this concept was ruined because the model was German legislation that is not so applicable, because we tried hard to educate parents. So also I would like to stress out, and then to give the floor, I used too much time, to my colleague, the right of the child to know his or her origin. It's a personality status right, but I think it would be, there will be cases when child will seek compensation, and it already happened in some comparative case law of some countries, that if this right is not secure to child, the child is seeking compensation against even their parents, and now it is also interesting in medical art reproduction, because if I can see the cases, future cases, where children are going to sue even state or clinics, because if their right to know their origin is not secured. And now more basic representation, more basic and practical presentation of status of the child and about legal representation, legal capacity, and so on. Please.
Thank you. Thank you. Hello, everyone. It is a special honor for me to participate today in this conference, and I would like to express my gratitude to the organizers of this really great event. Thank you so much. My thanks also go to my dear professors who gave you an introductory overview over Croatian family law concept. And I will continue this presentation by focusing on some aspects of legal position of the child in Croatian private law. Croatian legal order, as you have already heard in the presentation of Professor Barca, in Croatian legal order, we have 3 levels of legal capacity. When I speak about legal capacity now, I think on the capacity to act, capacity of a child to undertake some legal actions, to make some legal transactions with valid legal effect. And firstly, and mostly common general position of the child in Croatian legal order is defined by his or her lack of legal capacity and a right to undertake legal actions through the legal representative. And the natural legal representative of the child are child's parents, but in some situations, child will be appointed a guardian. In some situations which are prescribed not only in Family Act but also in some other legal acts, a child has limited legal capacity, and that means that he or she is able to enter in some legal transactions and undertake certain actions with valid legal effect. Very similarly to the other countries, full legal capacity a child acquires at the age of majority, or earlier if he enters into a marriage with 16 years of age. As I already have said, as I already said, children mostly undertake legal actions through a legal representative, and first entitled to represent their child are child's parents. This is their right and duty that derives from their parental care. And parents are obliged to talk with their child and to try to reach an agreement with the child in accordance, of course, with the child's age and maturity. And the older the child is and the more mature the child is, the greater is the influence of his opinion on the decision-making process connected to his or her representation. Both parents have the right and duty to consensually represent their child and undertake legal actions on its behalf, but there is a presumption that one parent has given consent to the other parent so that he or she can represent the child without other parents' written consent. So the express written consent of the parents is required only in cases of representation of the child regarding his or her essential personal rights, as our Family Act says, and concerning valuable property. Furthermore, in those cases, supervision of the court is prescribed. Namely, if parents cannot agree about representation of a child regarding essential personal rights, and this includes decision of changing personal name of the child, or place of residence or religious affiliation of the child, then the court will render a decision on which parent is going to represent the child in this particular case. Also, representation of the child in connection with available property or proprietary rights is valid if the parent who represents the child receives not only an express written consent of the other parent, but also court's approval. On the other hand, a legal representative crucial for the protection of a child who is without parental care is the guardian. Considering that guardianship substitutes parental care for minor wards, the guardian shall consciously represent the minor ward and care about his or her personal as well as proprietary rights. There are some limitations in representation powers of the guardian. Namely in the situation in which guardian can take some legal actions representing a minor ward only with prior consent of the supervisory body, and in Croatian legal system it is Croatian Institute for Social Work. For instance, only with the prior consent of the institute is the guardian entitled to decide on choice and change of the school of the child, or decision on termination of child's education or employment, or to take more important measures in relation to the minor's ward personal rights, or to take actions that exceed regular management of the minor's ward's property and property rights. When we talk about the limited legal capacity, Some of examples of limited legal capacity of the child in Croatian legal systems have already been said, and those examples are from our Family Act as a crucial legal act. For family law, I would just add this about this limited legal capacity, one interesting thing that according to the special act that is not listed here, and that is the Act on Health Measures for the Exercise of the Right to Free Decision on Childbirth, it is prescribed that 16-year-old child can independently file a request for termination of pregnancy. So we have also some preconditions for acquiring limited legal capacity in Labor Act, according to which 15-year-old can conclude and resign the specific employment contract and to carry out all the legal actions related to fulfillment of obligations from this contract. And also, according to Succession Act, there is a possibility for a 16-year-old child to independently make a will. Considering the rights of the child, considering the rights of the child in court proceedings related to family status, it is important to emphasize that the child has procedural position of a party in every maternity or paternity proceedings. When it comes to the proceedings to establish maternity or paternity, the child has the right to file a lawsuit, and he or she can file that lawsuit up to the age of 25. During the child's minority, the lawsuit can be filed on behalf of the child by his or her legal representative, and there is also the possibility that the child be represented by the Croatian Institute for Social Work in a proceedings to establish paternity if child's mother gives her written consent for such a lawsuit. A child also can file a lawsuit to contest maternity or paternity until he or she reaches the ages of 25. If he is a minor, then the lawsuit is filed on his or her behalf by a special guardian appointed by the Croatian Institute for Social Work, since there is a conflict of interest between the child and his or her legal representatives, namely the parents. There is also a possibility that if the child reaches the age of 14, that child be granted litigation capacity. Namely, the court, at the request of the child, will allow the child of this age to present facts, propose evidence, and undertake other actions in the proceedings if he or she is able to understand the meaning and legal consequences of those actions. The child's right in these proceedings is also to be informed about the merits of the proceedings, the course and the possible outcome of the proceedings in an appropriate way, suitable for his or her age and maturity. Also, child's right is to express his or her opinion, and the court is obliged to enable the child to exercise this right. After the end of these proceedings, child's right is to be informed about the content of the decision and the right to file an appeal. It can be concluded from this that family law provisions try hard to ensure the child's right to know his or her origin in judicial proceedings. And finally, I would just say a few words about rights of the child during adoption, and especially about the rights of the child to know his or her origin. One can say that there are three most important cornerstones, I would say, of adoption procedure, and all can be summarized in only 3 words, and that is focus on child. This perspective is being forgotten sometimes, unfortunately. Namely, at the center of the adoption proceedings is the child, child's right to family life, and adoption can only be established if it is in accordance with the welfare of the child. And this is the basic criterion for the adoption decision, has the meaning of paramount consideration, decisive factor, and standard that must take precedence. It is also important to emphasize constitutional state obligation to devote special care to minors without parents and those whose parents do not take care of them. When it comes to the rights of the child in the adoption process, the child is a party in these administrative proceedings. If the child is 12 or older, his or her consent is required to establish the adoption. The given consent can be revoked until the decision is final, and if the child is under 12 years of age, consent is not required, but the child has the right to express his or her opinion about the adoption. And this opinion will be taken into account in accordance with the age and maturity. The consent of the child who has reached the age of 12 is also required for a change of personal name and nationality, as well as for determination that the adoptive parents are entered as parents in the birth registry. In the Institute of Adoption, the interest of the biological parents, adoptive parents, and the child are intertwined and often conflicting. Croatian family law system gives clear and unquestionable priority to the interest of the child. Namely, in Croatia, there is no possibility of anonymous childbirth. Duty of the Croatian Institute for Social Work is to inform potential adopters about the child's right to learn from them about the adoption. And finally, I will conclude with the child's right that he has the right to insight into the adoption case files and the birth register during minority only if Croatian Institute for Social Work establishes that such insight is in the child's interest. So this is just really brief overview of some aspects of legal position of a child in a Croatian private law. Thank you very much for your attention.